Members, the meeting of the Committee on Members' Interests is now called to order. We have several items on the agenda. Item 1, a proposed revision of the procedure for handling complaints. At our previous meeting, we decided to amend the procedures and principles for handling complaints. Basing on that, the Secretariat has drafted a set of amendments for our reference. Now, in handling complaints, we had about 10 meetings, and we were just studying the matter rather than handling the matter. And basing on your views, we've asked the clerk to draft the amendments. I'll ask the clerk to highlight the major points of the proposals. The clerk, please. Thank you, Chairman. With regard to handling procedures, members may refer to Appendix 1. As for the proposed procedures, it's proposed that the Secretary will deal with the the complaints that will not be handled by the CMI. They are the anonymous complaints or unidentifiable, or the complainant is unidentifiable. At present, usually we do not handle such procedures. Yes, you may refer to Appendix 2. In fact, the Secretary or the clerk is referring to this. As for existing procedures, there are no rules to provide for the handling of anonymous complaints. We've taken a note of the handling of complaints by the House of Commons in the UK and also in Canada. They are only dealing with persons the complainants that can be identified. We therefore have also suggested we follow the same approach, that we will not handle any complaint that is anonymous or the person that cannot be identified, the person doesn't want his identity to be disclosed. Now, the time limit for the chairman to decide and whether to hold a meeting is extended from 7 days to 10 working days. And the procedure, and we also propose to delineate clearly between the consideration stage and investigation stage. In the consideration stage, or rather certain steps will only be taken during the investigation stage, such as investing the member under complaint to attend the meeting, in deciding whether the complaint can be established and whether there will be a report submitted to the Council or whether there will be sanction. This will only be considered during the investigation stage. The consideration stage is to decide whether the committee will enter the investigation stage to investigate the complaint. In the consideration stage, the committee will only consider the information provided in the complaint and also readily available readily available information such as media report and register of interest. It's also proposed that in considering whether a recommendation on sanction will be made, one factor to be considered is whether the breach whether the matter is does involve any conflict of interest between the member and his role as a member of the Council. Under the present procedure, if the complaint is not established, the CMI can decide whether a report can be made or not. There is a new procedure, and that is a member can give advance notice or can give advance instruction whether they would like to be informed of any complaint against them which the CMI decided not to consider or investigate. The CMI may also invite or order by summons any person to attend his meeting and under the Powers and Privilege Ordinance, and the member under complaint can be accompanied by at most 3 persons, but such persons may not interfere with the meeting. Or rather, the member should the complaint should be conducted in private. The discussion should be conducted in private unless meeting is asked. The member asked it to be an open meeting. The CMI has to provide the draft to the member, and also the views considered before finalizing the report. Thank you for the report. There is a comparison of the current approach and the future proposal. I suggest we turn to Appendix 1 and look at each and every point of the proposed procedures. They are not very complicated. In fact, they are just to clarify certain points which have not been clear in the past few years. The changes are not substantial. If there is any substantial change, it's just the extension of certain period of time. And also, we clearly reject any anonymous complaint. And also, in respect of establishing a case and also making recommendations on sanctions, the provisions have been clarified. This is not very complicated. Shall we start with Appendix 1? Let us go over the paragraphs one by one. Part 1, initial handling of a complaint. The clerk has already highlighted the major points. Number of working days, 2 days for extended from extended to 3 days for making a decision. Now, can you highlight the points? This has been redrafted. Is it entirely redrafted? Can you highlight the change? I've already highlighted the change, but there is no markup copy. There is no markup copy because there is quite a lot of textual changes. Now you can look at our old procedure. This will address the point raised by Ms. Emily Lau. The clerk has highlighted Appendix 2. Now, the texts have been substantially revised, but the content has not been changed substantially. Well, can you highlight the changes? Say, for example, the call of the first meeting. Let me speak on each paragraph. Part 1, initial handling of a complaint. It is a decision whether to call a meeting to consider the complaint. In paragraph 1, Ms. Lau asked you to compare this with the original proposal. Paragraph 1, if you may turn to the original procedures, the first paragraph of the original was very complicated. Now we divide them up. First, we receive the complaint, and then we set out those complaints that will not be considered, say, anonymous complaint, a person who cannot be identified, so on and so forth. basically they are the same. What is added is if it is outside the purview of the committee, then it will not be considered. Originally, this one wasn't present. It was for the chairman to decide whether it was within the purview. But under the new tool, the clerk will do the screening. If it is obvious that it is outside the purview of the committee, it will be rejected. And then as for the date of meeting, it has been changed. Or the days for making a decision, it has been changed. Others remain unchanged. In the new version, there will not be the provision on the calling of the first meeting. Instead, it will be initial handling of a complaint. This is part 1. The chairman makes a decision basing on within 3 days instead of 2. Originally, it was only 2 days. Even it wasn't the decision by it isn't a decision by the chairman. It's a decision by the clerk. Say if it's a complaint against a former member, then it doesn't fall within the scope, and it doesn't need the chairman to make a decision. The clerk can already screen it out. The initial handling of a complaint will clarify the arrangement for calling the first meeting. And then part 2, consideration of a complaint. We first start with considering a complaint. Maybe the secretary can move on to this part. At present, for consideration of a complaint, at present is equivalent to the preliminary consideration of the present version. In our new version, we take away the procedures that will be done during investigation, say inviting the member under complaint to come along and produce documents. So the consideration of a complaint has been simplified. It is based on information contained in the complaint and also some basic information before the committee decides on whether to conduct an investigation or not. In other words, during preliminary consideration, we also included the procedure for investigation. Now, after the amendment, we will do only preliminary consideration. We look at available information, including the information provided by the complainant, and also the information readily available, such as the information in the register, before we consider whether we conduct an investigation into the complaint. In the old version, quite a large part of the preliminary consideration will be put under investigation of a complaint under the new version. If members don't have any questions, let us move on to part 3, investigation of a complaint. Investigation of a complaint, part 3, has some procedures that are in the past under preliminary consideration. That is, these parts are, these paragraphs are inviting a member under complaint to provide information in writing, or gather or cause to be gathered information relevant, so on and so forth. The persons, relevant persons, complainants, and members under complaint are invited to give information in writing or to be present at the meeting.
If we don't have questions, we move on to the new part 4. The new part 4 is called Report to the Council, and in the old version, it was a different name. It was a decision whether the CMI made a decision. There's no big change, with the exception of my previous briefing. That is, whether there is a breach between the role of a member and the member's complaint. The rest is just a rewriting. That is part 4. When you say smoothing out the writing, so you think that the two parts are actually the same, or they're referring to the same matter? Well, the old writing had one consideration: the breach of the member that has received the complaint, whether it was deliberate, there was deliberate intention. Well, we have taken reference to some old cases, and we've taken the wording from those cases and used those in the new version. So there might have been deliberate behavior and well, in the recent case against Mr. Ho, we were using the wording of whether it was a deliberate intention to decide whether we should follow up. So at this point, it seems to have summarized the past few cases, and we had used this approach because it's hard to give an accurate description of an inadvertent mistake. Well, we have some addition here, whether there is involved any conflict of interest with the member's role as a legislative council member. In the past, we were focused on this. That is, a person's role as a LegCo member. So what is the effect if we all decided that that is the case? After an investigation, we have a discovery of the facts, and we take these facts and compare it against these 2 points. So whether there was a deliberate act and whether there was any conflict with the member's role as a LegCo member. We do consider other criteria, but these 2 would be the focus. In the past, we didn't have item B, but in our recent cases, we had considered point B. So if you add the criteria A and B, so we have tightened. Can we understand it that we have tightened our? No, that's not the case. That's what we were doing in the past. It just wasn't spelt out as clearly. So perhaps the secretary could elaborate. In paragraph 18, it says the committee can consider some factors. This is not the only limit. We've just highlighted 2 criteria that could be considered. If you look at the writing, we look at whether there is evidence that the breach of the relevant rule of the ROP by the member under complaint involved any conflict of interest with the member's role as a LegCo member. So the CMI, first of all, has to investigate whether it was a deliberate act, whether there was a conflict of interest, and it's slightly different from the original wording. We had to consider whether it was an inadvertent mistake, so it's worded slightly different. You can't say it's been tightened. there's just one more criteria to consider. Mr. Fan's question is, in the past, did we not use this principle, and has it been tightened? And in my handling, I have felt that we have not been tightening the restrictions. We had just accumulated experience, not just the previous case, but in the previous legislative year, we were using that approach. In the new wording, it reflects the last legislative year and this legislative year's criteria that are considered. This is a more accurate reflection. So nothing has changed. You still have to have these elements, but it's just worded clearly now. So even if you didn't, even if you hadn't highlighted this, you would still investigate along those lines. So after the facts have been established, we compare the facts to these two criteria. We're just making it clear now. We've always felt that we should consider whether there was any conflict of interest with the member's role and whether there was a deliberate act in order to arrive at our conclusions. I personally don't feel that there has been any addition or reduction. We've just clarified it. We move on to Part 5. The remaining three parts, suspension of work and confidentiality requirements and participation of members, are more or less the same as the old version. There's just some amendment in the writing. So what kind of drafting improvements have you made? The only item worth mentioning is that in confidentiality requirement, anybody participating in a camera meeting will have to sign a confidentiality undertaking that the member or person will not publish, and it is before the report is submitted. So does that mean that it can be disclosed after it's been submitted to the council? So we have a new section saying that there is no time limit, whether they have their confidentiality undertaking, it remains the same even before or after submitting the report to the council, unless the information is made open to the public. Otherwise, it will still have to retain confidentiality. Any questions? In our internal discussions, there was a signing of confidentiality undertaking. My understanding was that if the CMI has made an authorization that it can be disclosed, otherwise, the old wording was that after submitting to the council, you could say anything you want, and that was not in line with the intention of the confidentiality undertaking. Okay. Part 7. Not much change there as well. Chairman, in item I, submitting a reporting to the council, and the CMI could decide, and after the amendment, after the investigation, the you have to submit a report to the council. So whether the complaint is substantiated or not, the report will be submitted to the council regardless. Well, in the past, when the complaint was not substantiated, we would decide whether to report to the council. And to a large extent, in the past, we had never entered an investigation stage. But now, after the amendment, when you enter the investigation stage, when work has started, now we have to report to the council. But if you have not entered investigation, then you don't need to report to the council. That's the difference. Is that correct, Secretary? In the last year and this year cases, in the preliminary stage, all the way to the end, we did not enter into an investigation stage. In these 2 legislative years, that has been the case. So, cases that have been concluded, even in the preliminary stage, the CMI in the majority of cases had submitted a report, even for unsubstantiated cases, unless we have individual cases where we felt that it was not worthwhile. So a very minority of cases had not had their reports submitted to the council. So even for unsubstantiated cases, they were submitted to the council. So in the original paragraph 20, there's a sentence afterwards saying that council members or other people cannot disclose any information. So does that remain in the amended version? The following part refers to confidentiality. So in the confidentiality section, that has already been covered. So anything else that you need to follow up or have questions? If you're satisfied with the arrangement, then we will take this amendment procedure should we submit this to the whole, to all council members? Because according to Section 73, the CMI actions and decisions will be decided here. We don't need to submit to the House Committee or the Council meeting. We don't need to. So, I suggest that if you're satisfied, we could submit it to the whole Council and consult them, and we'll tell them it's clarified and upgraded. We can, if necessary, we can come back for further discussion. If not, if we all agree, then we'll present the final version for endorsement. So in our next meeting, that's what we'll do. So is everybody satisfied? We can agree? Then this discussion, agenda item 1, will conclude, and we enter agenda item 2. According to ROP 83A, we have to disclose pecuniary interest, and during the scrutiny of the Stamp Duty Bill 2012, members of the Bills Committee concerned raised some issues about compliance with the Rule 83A. And you recall that in each bill committee meeting, everybody would have to declare, because the stamp duty had highlighted the fact that a lot of members had property interests, and just declaration of interest would affect the scrutiny of the bill. So therefore, on the last occasion, our committee, we had accepted the House committee suggestion, and we had the secretary look into this to see regarding Section 83A whether we had to make any amendments.
Now
the papers before you, CMI 30/1314. I believe you read the paper. Maybe the clerk can highlight the salient points in the paper, and then members may comment on the proposal. With regard to the view of the concerns of the Bills Committee on Stamp Duty, there are two concerns: whether a member is required to disclose a pecuniary interest which is in common with the rest of a sector of the population of Hong Kong, such as owning a property or having the likelihood of selling one's property. That's what we call common pecuniary interests. Members were also concerned that if they are required to disclose the same interest in at each time of at each meeting, that may affect the proceedings of the meeting. Under Rule 83, there is no clear stipulation on whether common pecuniary interest should be declared, but under Rule 84.1 and also 84.1a, two exceptions have been provided, except where his interest is in common with the rest of population of Hong Kong or sector thereof, or his vote is given on a matter of government policy. If there is direct pecuniary interest, but if that interest falls within these two exceptions, then under 84.1 and 84.1a, they can still vote, and they don't need to abstain from the meeting or withdraw from the meeting. As for the Parliament in the UK and Parliament in Canada, members are not required to declare interest common to all members. Having considered 84.1 and 84.1a and also overseas experience, members may consider whether common pecuniary interests should be exempted. Another question is whether at the same at different meetings of the same committee on the same matter, whether such interest should be declared. Members may refer to the practice of the UK House of Commons. When they they usually declare that they are required to declare interest at the first meeting when they speak. Otherwise, they don't need to. At subsequent meetings, they don't need to declare interest unless there is a amendment which is directly related to the interests of the member, and the member intends to speak on that. The modus operandi of the committees in the UK are different from that of our Bills committees, but the terms of reference are clearly defined, and when members join the committee, they can easily declare their interest. Should we adopt the same approach of the UK? If members are of the view that the recommendations under 16A and B are worth considering, and then members may consider amending 83A. That is a proposed draft for members' reference.
就即係而家睇過其他嘅啲議會，主要咧就睇翻英國議會咧， 佢對法案方面。
Now we have looked at the practice in other parliaments, and they have very clear objectives. Their public bills committee or their public bill committees have clear terms of reference. Now, in our bills committee, we do have clear objectives, but it's different from our panels are different. The topics discussed at the panels do change all the time. I think for the panels, we may not be able to adopt the practice of overseas parliaments, but for bills committees, we may make a change along the same line, and that is there will be a one-off declaration at the start. And after the first declaration, there can be a technical arrangement. The information can be put online, so the members of the public will be aware of the declaration. There is no need to require each a member to declare interest at the beginning of each meeting. Is it agreeable to members? If you find it agreeable, then we will look at the amendment under 30 in the appendix.
6同我哋原本83A
The appendix, is it the amendment, proposed amendment? If you look at ROP 83A, it is very short. Now it becomes very long under the proposal. Let us consider the issue first, the principle first. Do you agree with that direction? Yes, Chairman. There are two things. First, the exception. If we agree on the exception, that will be realized in subparagraph 3. Subparagraph 3 is section 84. That's very familiar. ROP 84 is the same. What's the difference? If you think that's applicable to the Bills Committee, then we'll go ahead. Chairman, I agree with the principle, but I want to see the difference between putting the one in 84 under 83A. It is not putting 84 under 83A. They do have the same reference. The reference is the members' interest in a matter is in common with the rest of the population of Hong Kong or the sector thereof. 84.1 is for voting, 84.1A is for withdrawal from the meeting, and 83A is for the declaration of interest or the disclosure of interest. Well, I have no objection. But if we adopt this, and then going back to the Bills Committee on Stamp Duty, then I don't need to declare interest because it is a common interest, or it's an interest in common. We look at the nature of the interest disclosed. There are two categories. I own a property. I may sell my property. That is interest in common, and you may not need to declare that interest. But some members may have individual interests. Say, for example, he is a property developer. Then he still has to declare interest. And under the new requirement, subsection 2, he is required to declare only once. Say he is a property developer, he does a certain business. After he has made the first declaration, then it will be put on the web, and then he doesn't need to declare that anymore in the future of such Bills Committee meetings. Yes, I think I agree with that. And then we should clarify what interests fall under Category 2 and what under Category 3. If he doesn't make the first declaration, then he breaches the rule. I agree with the new arrangement. Thank you, Mr. Emily Lau. Yes, Mr. Gary Fan. Let me answer your question. I don't agree with the new arrangement or the general direction. I've already said that before at previous meetings. I don't think that making a declaration before each meeting is wasting too much time. It's just some 10 or 15 seconds for making a declaration. This is a very important principle. This is to let people monitor the interest relation. This is to protect the overall integrity of the Council. I still believe that we should maintain our original arrangement. The original 83A is adequate, even though I know that the Secretariat has collected a lot of information and has made reference to the practice in the UK. Now, there was a case against 3 members, and I don't think the change, such a substantial change, should be made. Such a substantial change is not proportionate. In fact, declaration of interest is to protect members from being, complained against when certain matters or information have been quoted out of context. A lot of things are now put on YouTube. People monitor us how to monitor the government. I think if we declare interest at every meeting, that will give people a clear impression that we are fair-minded, and I think the present arrangement is adequate. Mr. Kwok, if you look at 84, it is about voting. Voting is more important than the area cover under 83A. When casting a vote, you still have an exemption if there is interest in common. 83A is less serious, and there is no such exemption. It is really disproportionate. That's why we think that's there is something not appropriate. Participating in a vote is a very important duty of a member. From that perspective, his right to vote should not be taken away lightly. 84(1) is in relation to direct pecuniary interests. 83A requires disclosure. As long as you disclose it, then you will not be barred from speaking. Therefore, disclosure is broader. You disclose it, your interest doesn't bar you from speaking. Therefore, the scope is wider. You need to disclose even indirect pecuniary interest. You need to declare interest even there is common interest in common. I understand your point. Mr. Fan, let me share with you my view. Mr. Kwok asks why we include interest in common under 84(1) and 41A, but don't have it under 83A at present. I share this view. It is not that I say I'm employed. It's not about to say I'm employed by a certain developer or I'm a director of a developer. Now we have no. We have only to apply this new amendment to the Bills Committee. Now the problem arose when we discussed the stamp duty bill. It did spend a lot of time. People kept declaring interest at the meetings. That was a fact. In fact, in studying the bill, the most important thing is to let members of the public know members' interests, and if the interest has been declared, then the public will be able to know it, even if the member has just declared it once at the beginning of the meeting or at the beginning of the first committee, Appeals Committee meeting, and the information is made known to the public.
喺呢方面咯。
Well, I see that everybody feels that there is a need for amendment, and of course there are some reservations. Is that correct? Well, if that's the case, this is a rule of procedure, so we need to hand it back to the Rule of Procedure Committee for discussion, and then it has to go back to the House. It has to go back to the Council meeting, so there's a two-step procedure ahead of us. So at this stage, is this amendment do we need to hear from other members and parties, and then we make a decision on the next meeting? We decide whether we should submit it to Rule Procedure Committee, and then the ROP Committee will decide whether they should report to the Council meeting. I agree. I don't think it will deprive any information. I think efficiency is important. We're just at the Bill Committee, and as long as you've declared interest in your first attendance, that's sufficient. Anything else to add? If we all accept the arrangement, I will take this amendment and circulate it amongst all our members for their views, and then if there are, we'll have to see if there are any views on our amendment proposals, and then we can summarize that on the next occasion, and then if we are all in agreement, then we'll follow the procedure, and we'll submit it to the Rule of Procedure Committee for a further discussion. We can undertake the next step. Can we all agree? Well, then we've concluded all our discussion items, and we can now deal with any other business, which is none, and we adjourn here. Thank you.